She's only, 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Hard letter she get for performance. And that's a really fine letter that supports Michaela.
Sentencing, you entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state? Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No.
Defense?
No,
State, any witnesses?
no.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin.
That PSI, the pre-sentence investigation, is basically the court's roadmap. It weighs her background, her mental health, her role in the crime, and the victim impact. Judges rely on this heavily. So when no one objects, that means what's in that report is fair game and potentially devastating.
Michaela's mom.
All right, Ms. Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. You can state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are that Michaela has accepted responsibility for the robbery here in Virginia.
Correct.
And today's date, she's in prison for entertaining her application for probation and first people.
Correct.
Second, let me just ask you, how old is Michaela?
So now she is 18. On the day Friday, she was 17.
When did she turn 18?
November 3rd.
And where is she? She made future plans, applied for universities or anything explaining her senior year.
Yes, she's accepted to UTSA, and we're pending.
Excuse me. Please whisper.
So, you know,
She was accepted to UTSA, and we're pending the application for going to university.
and how is she doing?
She's doing good. She's on the honor roll. Right now, she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer support?
She did.
God, I can list the, state for their review. Something you'd like to do with the judge.
All right, any objections to the court reviewing? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of her?
Michaela's right now, she's since her release. She's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
Well, I can take you back to, I guess, the time around this offense. Before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active?
He's not active. Not just.
And does she have any siblings?
She does. She has a brother and a sister from her father.
Like living in your household?
No one. Just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that had been locked for some very serious offenses?
Yes, I do.
Can you tell the court what your response was?
So she used to sit there. I left her in there. She needed to understand what she had done, take responsibility. I left her in there for 5 months before I bonded her out. To understand that she didn't do anything. It wasn't something small. She needed to understand exactly what she did and what she could look for. She gets into a prison, the county, what jail was.
And do you think those 5 months have significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back.
This is one of the most powerful moments in the room. A mother who could have bonded her child out chose not to. 5 months in jail as a lesson. That's not punishment from a court. That's accountability at home. And judges absolutely notice that.
Definitely has a true meaning of what jail is.
And was that your goal at the time?
That's definitely was my goal. Because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson. And hopefully we don't ever have to revisit this again, which I don't think we will. Honestly, think when she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was depressed and had low self-esteem until, like, she had suicidal thoughts. It's a little weird. But, they let her out and she did a little counseling here and there. So I think she was just being more rebellious to herself. Um, I honestly didn't know it was mental health issues there. But once I did know, I got her help.
What mental health issues have you discovered from her, you think?
Definitely depression, low self-esteem. We've been going through exercises, counseling sessions. Um, and me myself, just trying to boost her up and get on the right to feel good about herself.
And do you think you're on a positive path right now?
Most definitely, yeah.
She's back living at home.
She lives at home. Her relationship is really good.
Here's the tension courts struggle with every day. Untreated mental health versus criminal responsibility. Depression explains behavior, but it doesn't excuse it. The judge is listening closely here, asking one question silently. Does treatment reduce risk or just explain the past?
More open. We actually have conversations about how she's feeling. I think we're on a really good path.
That's different than what it was before.
Most definitely, she would see us so much, felt like in our room. It's just for me what I thought was normal teenage stuff. But definitely it was a little deeper than that.
Miss Franklin, you own the business. You tell the judge what you do.
I do. I mean, children at my salon. I have some things to me.
And have you and Michaela talked about her interest in working in the salon?
Yes. Before this, she did. She was my assistant. To be honest, I need her back after my assistant. She wants to be a barber, and to get her through college. So it'll be good for her to go back. And I can. I'm also an instructor, so she can get some of her hours for me.
You mentioned that she's been sent to UTSA.
Yes, she's been accepted to UTSA, but she's also we're pending the application for pocket only, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months, and now she's being on trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up to court, but
Yeah.
other than that issue that was straightened out here, do you think she's been compliant with all rules?
Yes, she's been compliant, and I also make sure she's compliant. We get home on time, leave before time. We don't take no choice. So yeah, she's definitely compliant.
I know that today we had the opportunity, three of us, Michaela, to go through the Senate report. You can see there's some raw feelings on the part of the list complaining.
Yeah.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear or facing the after was actually that fear?
Yeah, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did. She wasn't able to actually go to the battered women's shelter, but she did produce toy drive. So where she marketed it. She a lot of toys. I think over 500. She took it back to Battered Women's Shelter. Um, she definitely is remorseful, and she definitely understands that she can keep people in fear, and it's not to be taken up.
Could you address very quickly whether you think your daughter would be a candidate for probation or education?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. Um, this was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months. And I understand that's not the same as 10 years, but she definitely recognizes in her condemnation for jail is to not do this again and not be in any more trouble and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Then that's all the questions I have. So that's an opportunity to ask you questions.
Yeah.
Any questions?
Were you aware that this offense occurred on February 2023?
Once I got a call from the Michaela, she's already in custody.
So you knew you did.
Yes,
And what day was that? Do you remember?
I do not.
Did it surprise you that it was in the case?
I mean, I don't know.
It was a win.
Yeah.
Would it surprise you that this offense occurred shortly before?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense. Did that surprise you? Did you know that it happened?
I did know. I mean, I've known since my reading the papers. And
Where should Michaela live?
she should have known at school.
So, do you know, did Michaela ever talk to you about what happened during this offense?
Yes,
So you're aware that the victim in this case was a mother of a young boy.
yes,
And you had a chance to read the incident.
yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what you're feeling when she's saying that prison would be appropriate.
I don't think it would be appropriate for Michaela for the simple fact.
Now you can answer my question. Was it surprise you or was it shock you that you was back in prison?
No,
Is it understandable?
it definitely is understandable.
Were you aware that the other people participated in this fight? That they were both young girls?
Yes,
So she was the oldest one out of the group, right?
okay, yes.
So she should be able to make better decisions than the others, correct?
I don't agree with that. The other two had been in trouble. I understand, and she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in Victor and son?
I understand that she was the driver.
Specifically that boxed in the Victor.
I
This is where the case tightens. Being the driver isn't passive, it's strategic. Boxing in a car with a mother and child turns a bad decision into a terrifying one. From the court's perspective, this isn't proximity to crime, it's participation.
All right. Any other questions?
The strength that I took out was the judge as a part of the other one. He would take Michaela to be evaluated by Marcos.
I agree.
His license.
Yes.
Judge, if I may.
Yes, you did. And I reviewed it. It's attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now. Is that correct?
Yes.
All right. Thank you.
Thank you for coming in. All right. Defense, call your next witness.
Judge, that's it.
All right. Did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right. So I want to let parties know that part of my question, or maybe you can address this, counsel, because it says that she is minimizing her role. And it says, regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure.
But then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed it actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been the process of explaining that to her. So I think that she's not minimizing her role as far as doing things for those young men. However, I think she's making a distinction that, contrary to what the state wants for, is that she was not the leader of this. She was a follower of this. And she did not possess or hold a gun. So I think it does to Miss Ballard's point of the PSI. Maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. The point of the matter is that she was in the car, not actively terrorizing these people. I make that distinction, but I also understand that she's there, that she's part.
All right. Because I'm reading PSI. I'm sorry, reading the stipulations. And the stipulations says that she was the one who boxed the driver in.
Because you know, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I wasn't told I think this policy was read in the ground sweater. She's saying she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, I just wanted to make sure.
Okay, thank you. All right.
I don't want to overstep. I do want to make it fun this time.
Yes, you may proceed.
She got started representing this young lady. She was in jail, and as her mother said, usually I have to feel those questions. How quickly can you get out of jail? I think Ms. Franklin took a very brave approach for a single mom. And that is, I want her to sit against serious charges. I want her to be in a taste of incarceration. I want her to understand that you have to penalize or punish for the things that you do. So 5 months passed by, and so I think the value in that here in the courtroom today is she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from really doing well in school. It's hard for me to believe she's 17 years old when I met her, and charged with such a serious crime. And she's turned 18, and she's only 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Her letters to get from friends, and that's a really fine letter that supports Michaela and her application for probation. I don't want the court to think that she's minimizing this, because I've only spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through talking that we had to theater sessions with Mark. And Mr. Hirsch is very good through the juvenile probation and through private practice of bringing these young people in. Young people who specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in this situation. You can't find yourself around this situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this is going to put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg the court to give this young woman a chance. The conviction, being sent to prison, is going to irreparably change her life. Now, I know that there's victims out there who have their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like her to stay in the court.
Judge, the situation here is that specifically targeted a mother and a child. That child's been damaged for the rest of his life. He's got immense trauma. And the role that Ms. Johnson played was an important one. She lost them and she's the why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what you have to make going forward. It's something now. The state feels that it would be appropriate here. Victims feel that it would be appropriate here. But we're at.
Judge, I just want to see more of these PSIs than I do. It looks like the juvenile offenders, I think, want the more serious role in this. I can't read this correctly, but it looks like one of them has dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, judges argue that there'll be some kind of equitable position here by the court to figure out what would carry on. Again, Judge, deferred adjudication on second degree felony is quite a thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean immediately damn the court. Here it makes a big difference because it gives her a chance to prove herself, and it gives the court a long reach to make sure that she's doing well. I don't know what else we can bring to the court to show that she's remorseful, doing well at home, doing well on positions above. So, again, we would ask the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in jail. I think she spoke about her to jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping we'll sway the court and give her a chance in the future without being another young black female with a conviction on.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentencing is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I would have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this was
the problem that she was, no matter what her role was, it was still going to be something that was erased because it's a right.
Yeah.
So under, and I'm not trying to argue the court, but under that circumstance, then no one should be eligible for deferred.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right, one thing I did notice in the letter from the psychiatrist, something that is bothering me, I've seen it somewhere here, is that Ms. Johnson, she said she gave them a ride, but did not know their intentions. She played her role boxing. She said that she had never had or held a gun. Police let her car, the boys threatened her, she didn't keep going. One of the boys threatened to shoot her, she stopped. No worries that brought up before that she mentioned that. She said that they threatened her. So it's just something that is,
Well, I believe it's her feeling. So it's not going to be in the police report. But I can tell you that was her feeling on this. She did feel threatened by these two young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's all I answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
Move on.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what is entitled trial court certification with your attorney? Did you understand it, and did you sign it?
6 years. Not the maximum, but not mercy either. The court acknowledged her growth and still chose punishment. So here's the real question. When rehabilitation is possible, but harm is undeniable, what should justice look like? Was this accountability or a future cut short?